Welcome to the Legal Podcast by Phoenix Bay Legal, and today we'll be talking about the most important judgment, famous judgment, I.C Golaknath case that happened in the year 1967. This was passed by the 11 judges bench, and the question of law in this case was can the Parliament curtail or nullify the fundamental rights granted to the Indian citizens by the Constitution? Can an amendment or to any section of the Constitution be granted as a law? Facts of the case of this famous case was that this is a very simple fact of the case was there. That is, the Golaknath family, they own about 500 acres of the farmland. But in the year 1953, the Punjab government had come up with the Punjab Security and Land Tenures Act. And as per this act, you can own only 30 acres of land. So that led them to to challenge the validity of this act. And the argument was which they have pointed out is again the right to property. That time, the right to property was one of the fundamental right, that is Article 19(1)(f), now repealed. The second one was the right to profession, right to going ahead with the profession of their choice. The third one was it is against the right to get equal protection as stated in Article 14 of the Indian Constitution. And the most important one, they have challenged the validity of the 17th Amendment, and they have urged that to declare the 17th Amendment as unlawful, through which the 1953 law came. So before we get into the judgment, there are four articles, I would say, which under the constitution law which needs to be understand first. The first one is a ninth schedule. What is a ninth schedule? Ninth schedule is basically a list of schedule of acts in which Supreme Court will not have a power. Supreme Court does not have a power to make any kind of judicial review. What is Article 31B? The Article 31B, in which states that any amendment or act listed in the ninth schedule of the Indian Constitution would never be eligible for judicial scrutiny. Those acts could not be nullified or reverted even if they curtail the fundamental rights of the citizen. It is the ninth schedule that the Punjab Security and Land Tenure Act resided in. Alright, so this basically the ninth schedule 31B are gives power to each other. Now, the third one is Article 368 and Article 30. So, and which is also very important in the Golaknath case. Article 368 gives the Parliament the constituent power to amend any part of the Constitution by means of adding new provision or repealing or modifying existing provisions. Article 13, whereas, state that any law that violates the fundamental rights of the citizen shall be declared void. However, the Article 368 says that no provision mentioned in Article 13 would affect the provision mentioned in Article 368. So that indirectly makes the Article 368 far more powerful than the Article 13. Another important doctrine which needs to be understood in this case is the doctrine of prospective ruling. Now, what is the doctrine of prospective ruling? Basically, if any law comes in picture against the old act which is unscientific or condemned rule, then the principle of prospective overruling applies. Though the law is new, but as per the principle of the doctrine of prospective overruling is that it will not affect the old law or old judgments. Alright. So that is basically the doctrine of prospective overruling. And because of this doctrine of prospective overruling, the Golaknath case is as such, it's like though they won the case, but despite of that, the act which they have come has not been declared void. Now the judgment. The Justice Subbarao came to the conclusion that the 17th Amendment violated the fundamental rights of acquiring any land and indulging in any lawful profession granted to the Indian citizens by the Constitution. However, since he used the doctrine of prospective overruling, the Supreme Court's ruling did not affect the validity of the 17th Amendment, and hence the 1953 law uh, remained. However, Justice Subbarao added that from then on the Parliament would not have no power to make any amendment to Part 3 of the Constitution that deals with the fundamental rights of the citizen. So basically, the I.C Golaknath case in the 17th Amendment, which is about the 17th Amendment, says that the Parliament cannot make any law which can violate the fundamental right if he wants to just have the one liner about the I.C Golaknath case. So this is the end of the I.C Golaknath case. I hope you liked it, my podcast. If you liked it, do subscribe and tune into another important judgments which change the constitution and the political scenario of the India. So bye for now.